What should I do after a strangulation arrest? This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. Well, we did work on a case one time that involved that, and I'm trying to remember now what happened. But a strangulation arrest is not like every other arrest. So what makes this one unique?
Well, prosecutors and law enforcement are trained to view these matters as potentially lethal cases. So they're prosecuted very aggressively. That's what makes them different than your normal case. And so that being said, the more experienced the attorney you have at defending these cases, the better.
So the very first thing that should happen if you're accused of strangulation is to hire a lawyer. So get that number ready and just call you, and then you can walk this person through everything from there. So what would you do then if someone approaches you and says, I have been arrested for strangulation?
Well, first of all, we consider the evidence. So when you look at a strangulation case, there's going to be those cases where the physical evidence is consistent with what the victim said happened. And then there are those cases where you just have a he said, she said type of scenario where there is not physical evidence, there's just the statement of the alleged victim. And so you look at those type of cases, two types of cases, and then you need to understand, how does a victim's statement develop? That is, when you're looking at the investigation, a lot of times the person who's complaining or the complaining witness doesn't come out and say, I couldn't breathe. You know, they talk about, he grabbed me by the throat, or he was trying to choke me. You know, they make statements, but then law enforcement leads them down a trail to fit the elements of strangulation. And so you look and see how that occurred. And if it occurred, you know, in a way where you think the victim was just embellishing or exaggerating because she's mad, versus, you know, she didn't say anything about losing her breath, and maybe she had some redness around her neck, and the officer just assumed that she was strangled. So you look at what was the evidence, how was it extracted from the complaining witness, and then you decide, okay, we need to approach those two type of cases differently.
So do you actually talk to her or the person who is doing the accusing?
About half of the time we do. So, you know, when we are able to talk to the complaining witness, because say that they're in a marital relationship and they were having an argument, and the case is charged and the complaining witness doesn't know that, you know, the defendant is now looking at a very serious felony, and they're able to re-examine their recollection of what happened. You know, they were intoxicated, they were mad. You know, maybe the reason they lost their breath is because they were crying and yelling and upset and, you know, in a physical confrontation with the defendant. And so there's a lot more context that you can get by interviewing the witness. And even if we aren't able to talk to the complaining witness, sometimes these incidents happen where, you know, there's part of the incident caught on the home security camera, or a neighbor or a bystander was able to observe something. So we're able to talk to the client to see what the evidence the state intends to use against him, and then figure out who else do we need to talk to, what else do we need to collect to support our theory of what happened.
That is a lot already done here, and this is all things that happen relatively soon after the arrest. But imagine, I guess, that this is probably going to go to trial. Are there more steps that need to happen then on the way to trial?
Well, yes. As we prepare for trial, we need to look at, okay, is this a case where it's just he said, she said, or is it a case where there is physical evidence? And if there is physical evidence, is it explained through another version of what happened? Or is it a case where with a strangulation, a lot of times if it in fact happened, you're going to see some bruising around the neck area, maybe some petechiae around the eyes. And so if this is the type of evidence that we're facing, now we need to switch gears and look at, okay, what can we do to negotiate this case? We need to try to get a plea deal that the client can live with, because, a felony like this on their record will haunt them for life. And so we prepare them by having them get into counseling, maybe get a drug and alcohol evaluation, so get some sort of treatment behind them, and then try to get a negotiated plea deal to maybe a lesser charge or a deferral. That is something, if you go through probation, you can get the case dismissed, or maybe both, so a reduced charge and a deferral. And in order to do this, we really have to have that reputation with the prosecutors, kind of like that case that you and I recently worked on, where we were able to get the case pled down to a breach of peace, that is, a verbal argument between the two parties, and the client avoided prison time. So it really is a matter of knowing what you're doing and really looking at what kind of case are we dealing with here. Is it he said, she said, or do we have a lot of physical evidence we have to try to neutralize to get a better deal?
All right. So again, when someone is in sort of the heat of the moment, this just happened, and maybe the accusation is being made, the person being accused is not maybe in their best mind, but what they really should do is take out this link and give your office a call. So how do they get that link?
Sure, we'll include it in the description, where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.